Welcome to Willis Weighs In, where we discuss controversial and newsworthy tax planning topics. I'm Ben Willis, contributing editor with Tax Notes. Today we'll be discussing FBAR penalties with Mark Oberstaedt and Ken All, who recently helped with a major taxpayer win. Mark serves as the assistant chair of the business litigation group at Archer. Ken's tax practice at Archer is quite broad and ranges from individual to business planning as well as litigation. Mark and Ken successfully represented Frank Giraldi in a very important case about the stacking of FBAR penalties. The key issue in US v. Giraldi was whether a penalty for a non-willful failure to disclose a foreign account is applied on a per account or per form basis. With that said, Ken, Mark, thank you so much for joining me today.
Thanks, Ben. It's a pleasure to be here.
Thank you, Ben. We enjoy being here.
Great. So happy to have you. Let me ask you, could you first tell us a little bit about FBAR, maybe its requirements?
Sure, I'll be happy to talk about that. The FBAR, which is a reporting document, there's no tax associated with it, but it is a requirement to report foreign financial accounts. And US persons are in this category of requiring to report this, whether they own the account or whether they have signature authority over the account. It goes back to the 1970 Bank Secrecy Act, but it has been changed over the years. Originally it was only intended to apply to someone who had willfully failed to file a FBAR report. Thereafter, in 2004, it was amended to provide for non-willful filings. And it imposes a different penalty for a willful or a non-willful. A non-willful penalty was the whole basis for our case. And it involved whether our client, Frank Giraldi, had non-willfully failed to file an FBAR and then been subject to multiple penalties instead of failing to file a single $10,000 penalty report. That was the whole basis of the case.
You know, Ben, one of the things that I love learning about the history of this from Ken, and one of the things that he's taught me is sort of how the government really started to go after people for these, because as he said, this has been on the books for a long time, but you're only starting to see cases about it more recently. I don't know, Ken, if you want to share that real quickly with folks.
Sure. What was really interesting about this is that a lot of people, a lot of accountants didn't know about FBARs back in the 70s. And then as time passed, still by the time that Frank Giraldi was required to begin filing these FBAR reports, he didn't know about them. And a lot of accountants didn't know about it because the IRS didn't really pursue it very hard. It all changed in 2008 when two cases came to the attention of the IRS. One was the UBS case where the IRS learned that United Bank of Switzerland had not been compliant with US tax laws when it comes to information that US citizens have to report. They were found to have actively coached US citizens on how to avoid paying US tax. And that case mushroomed into a lot of litigation between the IRS and UBS. There was another thing that happened in 2008 involving Liechtenstein. A disgruntled bank employee in Liechtenstein in 2008 he sold information on foundations that had been set up for the purpose of avoiding German tax. He sold this to the German government and pocketed about 4 million pounds in 4 million euros in this process. What occurred was knowledge that there were a lot of non-filers, a lot of tax cheats who were dealing with European banks and financial advisors. That led to the voluntary disclosure program by IRS, which initiated a way that taxpayers could come forward, present their information to the IRS, and seek a very substantial reduction in potential penalties. This process, though, was very useful from the IRS standpoint because they then learned of all the information on various companies and financial institutions that were advising US people on how not to pay US tax. So there was a normal outgrowth from those initial cases to great amount of information coming into IRS, which confirmed that there was a tremendous amount of reporting of information that had not been disclosed.
Very interesting, Ken. I've got to ask you, do you think the timing of these incidents around 2008 and the focus on enforcement and also could have had an impact on FATCA and just the focus more broadly on not only the individual taxpayers, but the banks and the countries?
Sure, because FATCA was really put in as a way of getting this information from the financial institutions instead of from the individual taxpayer. And by enforcing the FATCA law on financial institutions, which needed to report information on US persons, meaning citizens and green card holders, they needed to report this information, otherwise they were prevented from doing business in financial institutions in the United States. So most financial institutions abroad have started to become compliant in FATCA. And with that information, you have the information coming into IRS potentially from two sources: the people that need to file their FBARs and the financial institutions themselves that are reporting the information to the IRS, which gives them an opportunity to link the information up.
Yeah, I always found that interesting. You might actually have to send these FBAR and FATCA forms to different places, but ultimately it's all under the umbrella of Treasury and all focused, I believe, with a large emphasis on tax evasion. And so there just seems to be I think there's even a web page on the IRS website that says the differences between the FBAR and FATCA forms, which because they're very difficult to tell. Sometimes there's overlap and whatnot. I really also appreciate the history you provided on the Bank Secrecy Act of 1970 and then the 2004 implementation of this non-willful penalty, which after reading this Gerald case that you both were so instrumental in, I know is very important. And from a statutory interpretation perspective, I found extremely interesting. And so I guess with that said, would you please share with us the history of this US v. Gerald case and how it came to be, and tell us a little bit about it?
Sure, I'd be happy to take that one, Ben. Right. So Frank Giraldi is not the person that we were just talking about in the sense of the people who were the targets for this when it was set up, because his fact circumstances is quite different. Frank worked for AT&T, was a longtime employee. While he worked there, he met his wife. She was about 14 years younger than he was. And when he got to the time of his retirement in 1991, he had to make a decision, like a lot of people do, about his pension. And the question for married couples when it comes to pensions is, are you going to take it based on your own life expectancy, or are you going to take it based upon the life expectancy of both partners in that marriage? And because his wife was much younger than he was, the payout was going to be significantly different if it was based on both of their lives. So Frank made the decision to base his pension payment on his own life, take that money as a lump sum and invest it. And so he went and he invested it in 3 annuities and 1 financial account over in Switzerland, because he trusted the Swiss banking system more than he trusted the US banking system. So he's not somebody that was investing in foreign accounts for the purposes of trying to hide money from the US government. He just had more faith in their system. When we got this case, Ken found out that Mr. Giraldi didn't know he was required to file an FBAR. And that made sense, because up until 2011, the government had not issued any guidance indicating, for example, that annuities were required to be disclosed on an FBAR. But when that disclosure came out in 2011, Mr. Giraldi decided to enter into the voluntary disclosure program that Ken was talking about. And when he did that, he went through the process. He gave the government all the information it would have otherwise gotten on the FBAR. But when it came time to look at the penalties, they could be pretty severe in that program. And so he elected to opt out. And after he opted out, the government came and hit him with the most severe penalty it could, right? There was a statutory maximum of $10,000 a year for each of 4 years. But then the government did something that we became really concerned about, which is it based those penalties on a per account basis as opposed to a per form basis. So he got hit with 4 separate penalties for 4 years, $160,000. And the government eventually, after Mr. Giraldi paid $60,000 of that, decided to sue him for the balance. And that's where I got involved as litigation counsel. And the first thing we looked at, and you hit the nail right on the head, Ben, was we looked at the statutory interpretation. How do you interpret what is the maximum penalty that the government can assess? And at the time, when we first got the case, it was really only one decision on this in the country. It was the Boyd case out in California, where the court had said at the district court level, we're going to go with the government's interpretation of the statute here, but didn't explain why. And so we had to jump into some real statutory interpretation issues right from the jump. As you know, and I think a lot of the people who watch your program know, that can be pretty interesting and fascinating stuff when you're talking about tax law. So fortunately, we had the opportunity to compare what was in the willful penalty provision that was initially put in 1970, compared that to the non-willful provision that was added in 2004, and the language was different. And so what wound up happening in our case was the court, and I think Judge Wigginton really knocked it out of the park. She just did a great job of looking at this statutory analysis, looked at the differences between the willful and non-willful penalty language, but she didn't stop there, right? She also looked at the reasonable cause defense language that was also added in 2004. And what she saw when she looked at these various provisions was that both the willful penalty provision and the reasonable cause provision had account-specific language in it, but the non-willful penalty provision did not. And so using what I think are traditional statutory construction rules when it comes to tax penalties, she said, look, unless it's really clear what Congress intended here, we're not going to interpret this broadly and impose greater penalties on people unless it's very specific that that's what Congress intended. And she concluded that Congress actually intended something different. So that's where we are with the Giraldi case.
It's a fascinating case, Mark. I think the judge, he could have taken it 2 different ways. I mean, you have this very sympathetic fact pattern with this this pension and figuring out how to take these amounts. We know the FBAR threshold is $10,000, relatively low compared to other thresholds out there, and if you were to apply, and of course this was discussed in the case, a per account approach, you could end up with an almost limitless amount of penalties. Of course, there might be some relief in other areas, but just basing it on the IRS's argument of what a per account should be. And then to your point, she also incorporated this fantastic discussion about the statutory construction, and I completely agree that it's the most fundamental, one of the most fundamental tools for statutory construction, which is reading its plain language. I guess the spin that I found particularly interesting here is that it involved looking at statutes that were written by different Congresses, one in 1970 and one in 2004, but nonetheless was part of a statutory regime that imposed these FBAR penalties and requirements, and was able to look and say, here we have this, like you said, this evidence of clear per account intent based on the plain language of the statute, not needing to look any further. And we don't have that in this non-willful case. And so based on all your hard work for your client, Mr. Giraldi, she reached a fantastic conclusion. So congratulations.
Well, thanks. I mean, it was a hard fought win for sure, and one that we're very proud of.
I'm sure, and I'm sure the client is extremely happy, and rightfully so. I think this is important reason that we like to talk about these issues and make people aware of their rights. And I know that's important to you, and fighting for clients like Mr. Giraldi, and who's simply trying to diversify his pension funds, mitigate risk, and in doing so was got caught in this so-called stacking of penalties. So really quadrupled what should have been his penalty. So I know this is tied so closely to the Boyd case. You mentioned it, but I can't help but ask you what your thoughts are on that case.
Yeah. So here's what is exciting about where this is going. I think, right, is the Boyd case at the time that our case was decided was at the district court level. The district court had ruled in favor of the government, and that case was on appeal to the Ninth Circuit, and that was pending while our case was being decided. And then 8 days after our decision comes out, the Ninth Circuit issues its opinion in Boyd, and it reversed the district court decision in a split 2-1 decision at the appeals court level. And so now what we have are all the cases that have been decided under this statute in the United States in contested cases now line up in favor of the taxpayers. And because we've been talking about statutory construction, I think it's really interesting when you look at Boyd, the difference between the majority and the dissent in that case, because the majority took the same approach that Judge Wigginton took in Giraldi, and that we'd also seen in another case out of Texas called Bittner, where they say, look, unless it's very clear that Congress intended to impose these penalties in this fashion, we're not going to read that into the statute. The dissent, I think, took a different statutory construction approach and looked to see, could you justify the government's position based upon language that's in the statute, as opposed to starting from the presumption that you need to have something really clear. So for people who like statutory construction, I think Boyd is a really interesting opinion to read.
Yeah, I agree completely. To your point, the dissent and the opinion that confirmed what I believe to be the correct view, the majority's opinion, really emphasizes the debate that folks often have in these instances of statutory construction and also tax penalties, which I think is a big deal. And they looked, if memory serves, to the venerable principle of leniency, and made sure that penalties should be viewed against the government's and the drafters construction, and so in determining its construction. And so there, I think that was one of the primary reasons the dissent and the majority reached different conclusions, is that where there was some uncertainty, that was a factor, I think, that played into the decision that taxpayers should be given the benefit of the doubt when there is that uncertainty. When you have a penalizing provision, a taxpayer should be clearly put on notice of what their responsibilities are and what that penalty could entail. And when that's not clear, it's again going to be interpreted against the drafter. And I think, again, that's the right interpretation. And of course, they incorporated in the Boyd case the similar analysis with respect to statutory construction. So it looks like, with respect to this issue for you, you've got these coast to coast wins now with the Third Circuit and here on the East Coast, and things are lining up.
Yeah, I think it's very interesting for a tax practitioner and for a litigator to observe that from 2004, when this law was implemented, to a year ago, there had been only the Boyd case, which had been in favor of the government. And since that time, there have been now 3 district court cases that have come in: the Kaufman case, the Bittner case in Texas, and our case, which have, for the first time, challenged the government's interpretation of this law since 2004. And I think it's fascinating that it has taken that long for somebody to pick this issue up, and have a court agree to address it. It takes a lot of determination and guts, both on the part of the practitioner who's taking a line that hasn't been used before, but also on the part of the judges who are willing to challenge the standard approach that had been taken for more than a decade. So I think it's really fascinating that a law can stay on its books with the interpretation being vague or uncertain for such a long period of time before it's challenged.
Ken, I'm so happy you raised that point. I think that's incredibly important. Thinking of all the taxpayers that allowed these over collections of penalties, because of a multitude of factors, the deference that the IRS is constantly seeking and indicating they have the right to in these instances. And, the IRS is an overwhelming contender. It can certainly make a small taxpayer feel like, well, how can I be wrong? When in reality, sometimes the IRS can absolutely push the envelope with respect to its authority to collect taxes and penalties. And I think that's why this is so key. And to your point, the fact that it happened for so long, we have this nearly 15-year window where people were just paying, taxes, these penalties on a per account basis, which just seems so egregious in my opinion. And now we have a writing of that. My question to you both is what about all these taxpayers who are now like, well, wait a second, I paid, way too much compared to what would have been the result if I had gotten Archer involved and Mark and Ken. And so I'm curious, do these folks out there have any rights to seek recompensation for their payments?
Yeah, I mean, I'll jump in first, Ken, and then you can fill in as well. But I think they absolutely do, Ben. And I think this is an area where we could see a good amount of litigation coming up now, right? So a taxpayer has a right to pursue a claim for illegal exaction. And one of the times you and I spoke, Ben, you actually tipped me off to a case called Mendu. And there's an old Supreme Court case that goes back to 1960 called Flora. And FLORA stood for the proposition that if you want to sue the government for taxes that you paid that you believe you shouldn't have paid, you have to pay the entire tax. You can't pay less than the entire tax and then sue. And so the question was, does that FLORA rule apply to FBARs? And just a couple of weeks ago, the Mendu decision, which came out of the Court of Claims, ruled that the FLORA rule doesn't apply to FBARs. And so even if a taxpayer paid less than the full amount of the penalty, they're going to be entitled to pursue a refund from the government under a theory of legal exaction. So I can definitely see some cases coming up. In fact, I've been contacted by some lawyers representing people who are pursuing that very theory right now.
There's another direction in this future of FBARs that I think you already are seeing in the government's pursuit of FBAR penalties. And I think that the trend line, the government has been successful with regard to getting willful penalties approved by courts. And that line, I think you could see a natural shift in the government's position on what's willful and non-willful, and try to shift more taxpayers into a defense of a willful failure to file. One, the penalties are a lot more, and it is sometimes a difficult line to decide the difference between a willful and non-willful filer. So, for example, there was just a case last month, the Genschtes case, which essentially said that a taxpayer who had failed to review his tax return, where the box is checked off on the Schedule B that you do or you do not have a foreign bank account, that failure to review the return was in itself a mark of willfulness, because you should have reviewed your return and you should have seen that that was false and then said something or not filed that return. Well, we know as tax practitioners that tax programs generally will automatically check off no, because most people don't have foreign accounts, and the default mechanism within the tax program puts down no. And you know, the truth is very few taxpayers who get their return either done on TurboTax or done professionally really sit down and review the return. But the government is going along the lines of saying, if you had a foreign account, maybe you didn't know about FBARs, but you should have reviewed your return, which showed that you did not have a foreign account when in fact you did, and that's willful. So I think we're going to see that trend in how the government is pursuing these cases.
And to make it even worse, Ben, the government has been taking the position in certain litigation that we've seen that it can hide the reasons why it chose to have a willful as opposed to a non-willful penalty behind the deliberative process privilege. So I think you're going to see a lot of litigation behind that issue coming up as well.
I got to break some of that down because that was very important. Three things I think we just talked about. I guess I'll go in reverse order a little bit. But one, the fact that you could neglect to check off a box and not be viewed as willful, I think is just preposterous. It's a facts and circumstances test. You have to look at the level of sophistication at the taxpayer you're looking at and making these determinations. Software is obviously a large factor that I imagine would be incorporated into that. But even if not, I could see situations arising. I mean, we were just talking about the fact that there's a IRS webpage that has to tell folks what the subtle differences are between the requirements between FBAR and FATCA, requirements. And I've had folks say, well, isn't the threshold $50,000? And I've had to say, well, that's for FATCA, not for FBAR. And so there's very subtle nuances, and the per account and willful and it's just for them to really look at that one box seems a little much in my opinion, and weak analysis. I hope there was some more analysis in that case. I haven't read it, Ken, but thank you for pointing that out. Second, it seems to me that there's a trajectory that's likely if the IRS is going to continue to do what it has, which is to push for the maximum amount of penalties, which was made by a good point by Ken, which is now if this law continues as it should, as these courts are aligning, in many instances, willful penalties are going to reap more revenue for the Treasury. And so they're likely to now seek these penalties and start investigating these cases, which is going to put the burden on you and your taxpayers to make this determination, to Mark's point, of how are we going to assess whether or not the IRS has some evidence that we may or may not be aware of that is now being provided globally on these things. And how accurate is that information? I mean, we all know about large mistakes that are made in these process, and so it just seems like an area where I hope there's some serious collaboration with the IRS on these issues, because I would assume that there's a lot of courts who are going to believe in these penalty instances. They should, strictly be construed in favor of the taxpayer, to make sure that there's a true spirit of the statute that's captured here. But it'll be very interesting. And then lastly, to kind of go back to that Flora point that we started off with, Mark, please make sure to keep me updated when the class action lawsuit starts, because it seems like there could be a big one there. And I can't imagine that there isn't a large group of people who want to hear about that. And I'm sure you're going to be kept in the loop with that due to your expertise and Victory here. And it's folks like Frank Giraldi and their willingness to stand up for these amounts, which may seem small to others and costly and bringing to court, but it's just admirable. So a lot of respect to both of you and him and everybody who's been a part of this process. I know we could all talk about this for so long. There's so many great, interesting issues here. Do you guys have any final comments before we wrap up, as far as either the direction that you expect in the future, or just generally? I know we've covered a lot.
Yeah, I mean, I'll jump in real quick. The case for everybody to watch who's interested in this is the Bittner case, which is now on appeal to the Fifth Circuit. The penalty, we didn't talk much about it here today, but the penalties there were $2.7 million in a non-willful case, based on the number of accounts. So we're going to see if the Fifth Circuit aligns itself now with the unanimous decisions of the other courts in the country, or whether it goes another way and creates a circuit split. So keep your eyes on the Fifth Circuit.
Very helpful. Thank you for that, Mark.
And I would agree totally with that comment on Bittner, because if Bittner now goes the way of the way the court went in Giraldi, then the government will not have a single circuit or district court case which upholds its position on the multiple penalties per year on non-willful failing to file an FBAR. Yeah,
I think that makes complete sense, and I have a feeling a lot of people are going to be paying attention to the Bittner case. So it'll be interesting to see how this unfolds. And I'm sure there's going to be more cases coming. So thank you, Ken and Mark, both so much for joining us today. Really appreciate your insights on all this.
Ben, thanks for having us. I love discussing this stuff with you.
Enjoyed it, Ben. Thank you.
Well, for those watching and listening, thank you for joining us today. You can find my articles, blog posts, videos, and more on taxanalyst.com. Please don't hesitate to send me your questions or comments. You can email me at ben.willis@taxanalyst.org, or you can reach out to me on Twitter at @WillisWeighsIn. Thank you so much.
Willis weighs in.